Attorney Kelly, I have a preliminary hearing coming up. What does that mean?
Well, it means you're at the second stage of the criminal procedure process. You most likely already had a preliminary arraignment where you got some form of bail and then you were to show up at your preliminary hearing. You may not have gotten bail or could not make bail, and you may be going from county prison to your preliminary hearing in front of a magistrate. The preliminary hearing, its purpose is to weed out any of the charges that it's obvious the Commonwealth is not going to be able to prove. The standard is that the Commonwealth is going to have to show that the crime they're charging was probably committed and that you probably committed it. They're going to have to show that they have substantial evidence to hit every one of the elements of the crime that they're charging, and if they can't, then it's the district justice's job to dismiss those charges so that the common police court doesn't have to deal with them. As a practical matter, you should hire an attorney before your preliminary hearing, because if you indeed have to go to a full hearing, you'll have to have a stenographer and you'll have to abide by the rules of evidence. This will also be an opportunity for your attorney to examine the evidence against you, have a record made of any testimony, and that's really important because if you have a police officer that's testifying to something at the preliminary hearing and it's on the record, then he can't later on, after he speaks to the DA, change his testimony to make it more favorable to the Commonwealth. So you want to really lock them in to what their testimony is going to be by asking questions, ending a line of questioning with, is that it or is that all, to kind of put a bow on the questioning so that other information can't later come in against you. Another thing that commonly happens at a preliminary hearing is deals are made where the lead offense will go up to court because there's probably enough evidence there for it to go there, and the lesser charges will get dropped in exchange for a waiver. Now, you need an attorney with you because you as a layperson are probably not capable of rendering documents, eliciting testimony, arranging for a stenographer to be present. It's just a little bit beyond the scope of what it would be advisable for a layperson to do. Typically, you want to hire an attorney before the prelim so that a deal can be made and you can be facing only the charge that you probably would be found guilty of and no additional ones, and it would save you money. And even if you plan on going to trial, you would have to hire an attorney before the prelim as an opportunity for him to prepare his defense and examine all the evidence against you. I think that answers your questions. If you have any further questions, the contact information is right below, and you can call anytime between 8 and 6:30 p.m. and I'll be glad to answer your questions.
Appreciate it.